off-duty Massachusetts police officer just walked out of court, acquitted of trying to kill a fellow officer. Here's what changed, in plain English, and why it matters beyond one case. According to People magazine and local reporting, a judge, not a jury, found the off-duty officer not guilty after an incident that unfolded while he was being served with a restraining order. The allegation was severe. Prosecutors said he tried to kill the officer delivering that order. The defense argued the evidence didn't prove that intent, and the judge agreed there wasn't enough to convict. Let's pause on that point about intent, because it's central to what changed. Attempted murder isn't just about something violent happening. The law requires proof, beyond a reasonable doubt, that the person meant to kill. Judges look for clear actions, words, or circumstances that show that intent, not just a dangerous moment or a struggle that got out of hand. In a bench trial, the judge is the fact finder, weighing credibility and evidence instead of a jury. That means the decision can hinge heavily on how consistent the testimony is, what the physical evidence shows, and whether the legal boxes are checked. So what changed today is the officer's legal status in a major way. He's not convicted. The criminal case on that top charge, and any related counts tied to it, ends with this ruling. He won't face a retrial on the same allegation. Double jeopardy prevents the state from trying again on a not guilty verdict. But that's not the end of the story, and that's where the impact comes in for other officers and the public. An acquittal in criminal court is separate from police policy, administrative discipline, or civil lawsuits. Departments in Massachusetts can still open internal investigations, and the state's Peace Officer Standards and Training Commission, the Post Commission, can review conduct, even in cases where criminal charges don't result in a conviction. That split, criminal law on one side, professional standards on the other, matters a lot for how departments handle off-duty incidents. There's also the restraining order itself. Even if a person is acquitted of a crime connected to how that order was served, the civil order can still remain in place based on a judge's earlier findings in family or district court. In Massachusetts, those orders can include conditions like staying away from a person or location and surrendering firearms for a period. That can affect an officer's ability to work, carry a service weapon, or even be on duty, regardless of a criminal ruling. For the public, the question is often, what does this say about accountability? In short, today's ruling doesn't rewrite standards for everyone. It resolves one case, but it does highlight how critical evidence is in high-stakes incidents, how specific the law is about intent, and how much departmental policy and state oversight do the heavy lifting on professional conduct after the courtroom phase ends. From a legal standpoint, what to watch next is administrative. Will the department release a use of force or internal affairs summary? Will the Post Commission open a review? In Massachusetts, those processes can take weeks or months, and outcomes can range from no action to training requirements to discipline or certification decisions. There's also the civil side. The officer who served the order and says he was targeted could choose to file a lawsuit, which has a different standard of proof, preponderance of the evidence, not beyond a reasonable doubt. For other officers across the state, the takeaway is practical. Off-duty doesn't mean off-policy. Departments will likely emphasize that point in roll calls and trainings, including reminders about how to respond when a court order is being served, how to secure weapons during tense interactions, and how to call for a supervisor or step back if emotions are high. These are the moments where clear steps on paper need to match real-world practice. For communities, the immediate change is that one set of criminal charges has been resolved. What hasn't changed is the expectation that incidents like this are reviewed in full, not just in criminal court, but through internal and state channels too. Transparency about those next steps, what's being reviewed and why, goes a long way toward maintaining trust. So, to sum up the what changed question, the case moved from allegation to verdict, and the attempted murder charge didn't meet the legal threshold. That shifts the focus from proving a crime to assessing conduct under policy and possibly civil law. And that's where the broader impact for officer conduct in Massachusetts will likely be decided. We'll keep watching for any official summaries, post-commission updates, or civil filings.